Hi, I'm attorney Joshua Prince, Chief Counsel at the Firearms Industry Consulting Group, a division of Prince Law Offices PC. Today I'd like to talk about a monumental decision from the U.S. Supreme Court that can affect a number of individuals that are prohibited under federal law here in Pennsylvania as a result of a DUI where they refused consent for chemical testing. The case is Birchfield versus North Dakota, and what the U.S. Supreme Court held in June of 2016 is that although a state may impose enhanced or additional civil penalties in relation to an individual that refuses consent to chemical testing, under the Constitution, a state may not enhance or provide additional criminal penalties for an individual's refusal to consent to chemical testing. Why is that important? Well, here in Pennsylvania, our law says with regards to a second or third or even thereafter DUI, if you refuse chemical testing, it is assumed that your blood alcohol content is the highest rate. With a misdemeanor of the first degree being at issue, where there is a second or third or more DUI, that would be prohibiting. So in Pennsylvania law, second, third, or thereafter DUI, where someone refuses any type of chemical testing, it would be an M1 or misdemeanor of the first degree. And since that can be punished by up to 5 years in jail, it becomes federally prohibiting. Under the Supreme Court's decision in Birchfield, that's unconstitutional. And what we immediately saw was a number of district attorneys basically saying, all right, we're not going to prosecute these people under the highest rate. Rather, it's general impairment because we don't have any actual testing to show their blood alcohol content. Since then, what we've seen is now district attorneys are directing any police officers when they pull someone over that if they refuse consent, to immediately go out and get a warrant. And I understand a lot of magisterial district judges have been, maybe shall we say, inconvenienced by a number of late night calls of recent by law enforcement officers requesting warrants so that they can do blood draws to determine the person's actual blood alcohol content. Why I'm doing this video is because of the importance for those individuals that were previously convicted or pled guilty in relation to a refusal to consent to that chemical testing. Based on the Supreme Court's decision, that sentence that was imposed upon you and the grading of the conviction are unconstitutional. In Pennsylvania, we have a Post-Conviction Relief Act that would allow for you to be able to go back and challenge that illegal sentence. Unfortunately, there's very limited time. So if you're currently on probation as a result of a conviction from refusal to consent, you're going to have more time than someone who has basically had this conviction for a number of years, maybe 5 years or so, hasn't been on probation for 4 years or something like that. So it's imperative that if you do fall into this category, if you were previously convicted of DUI as a result of a refusal to consent to chemical testing and are prohibited at the federal level, you should contact us immediately because we can file a Post-Conviction Relief Act request on your behalf and get you relief. Because what should happen is the court should withdraw that finding of guilt, enter a finding of guilt in relation to general impairment, which would be a misdemeanor of the second degree because it's an ungraded misdemeanor, and that would not federally prohibit you. Anyway, I hope you found this video informative. If you have, please click the like button. Please share it with your friends. If you have questions, please leave them below. If you have ideas for other topics that you'd like to see us discuss, please leave those below or email us. And I hope you have a great day. Thanks.